about sports, because that usually makes us happy. Several weeks ago, it may have been more than a month now, a follower tagged me in her video, and I'm sorry I couldn't find it. I was going to try to tag you, about this House settlement with the NCAA and all the rule changes and everything that are going on. And I went and read it, and I made all these notes on it, and then got sidetracked. So today seems like the perfect day to talk about it. So for those who don't know, there was a huge lawsuit filed a handful of years ago by a group of student athletes against the NCAA claiming antitrust violations. Now, the NCAA has been sued for antitrust violations multiple times. And the basis for antitrust violations, there's a federal law called the Sherman Act in the United States. And essentially it says this is supposed to be a free market. There's supposed to be competitive marketplace happening, which is supposed to benefit not only people in the marketplace that everybody gets to try, but also benefits consumers because it creates people trying to get the best prices and the best quality. That's what you want a free competitive market to look like. And when that stops happening in a certain industry, that's a problem. And so you can either bring a private lawsuit for that, or there's also some government agencies that have the power to bring antitrust lawsuits like the Securities and Exchange Commission. But this case was brought by a handful of NCAA athletes. One of them's his last name is House. That's why it's called the House settlement. It sounds like they had a settlement in a house, but that's just the person's name. But there had been antitrust cases before about TV rights and coaches' salaries and all that kind of stuff. But this is the case where they finally said, look, this is a cartel. The NCAA and the Power Five conferences, all of them were sued as the defendants. They are engaged in a cartel where they completely control college sports. They take all of the money, they set all of the prices. It's all to the exclusion of the athletes, by the way, and we're sick of it. So they sued the NCAA and the Power Five, which if you don't know are the Big 10, the Big 12, the Pac-12, the SEC, and the ACC. And the argument they made is, we know that there is a competitive market for college athlete related stuff. And we know that because the coaches have shown us there's a market for these services. And they use as an example, Dabo Swinney, who's the football coach for Clemson University. He had some saying that he did and everyone thought it was funny. And so they put it on t-shirts and they sold all the t-shirts and Dabo got a cut of the profits. And they're like, how come a coach can do that, but a student can't? So we know there's a market out there for this stuff, but we as students are not allowed to participate in it. And that's a restraint of trade. They also pointed out, which I thought was very compelling, that the schools are selling access to these students and making money off of that with, again, no benefit to the students. And so they cited these fundraisers that big football schools in particular will have and say, pay $20,000 and sit next to the quarterback at the dinner. And the students are like, we see nothing. We're the ones doing all the work. We're the ones that are getting them all this, and they're all conspiring to keep the money for themselves. So the first thing they had to do in this case is they had to certify a class because this is a class action. And in a nutshell, I'm happy to do more detail if you guys have questions. In a nutshell, a class action is when a group of people say, we have experienced harm, and there's a whole group of people out there who have experienced exactly the same kind of harm by exactly the same people in exactly the same kind of way. And we are suing on behalf of those people for that relief. And whatever relief we get, they can then join in it with us. So the class that they had to certify, and by the way, you have to go through this whole class certification process before the case even really starts. It sometimes can take years. They had to certify a class of all the athletes who had been harmed by this activity. And the class was limited to D1 athletes at Power 5 schools over a certain period of time. They ultimately were able to get the data and figure out that this was about 300,000 people, a few less than that. And so the class was certified to say whatever relief is obtained by the plaintiffs in this case will apply to all 300,000 of those folks. So the three classes, there's a class and then there were three subclasses that were certified in this case. It's men's football and basketball, women's basketball, and then this other miscellaneous D1 sports. They're all D1 athletes and they're all at Power 5 schools. So the class is limited to people who fit into those categories. And then you just go about litigating the case. Because this was going to be incredibly expensive and long and difficult and in the press, The judge went ahead and appointed like a top-notch mediator to mediate this case a while ago, and they worked on it for, I think, 2 years, and finally they were able to mediate a settlement between the plaintiffs on behalf of themselves and everyone in those classes, and the defendants, the NCAA and the Power 5 schools. His name is Eric Green. He's a professor of some kind, and he apparently did a fantastic job. But because this is a settlement for a class, right? Because what the plaintiffs are agreeing to is not just on their own behalf, but on behalf of the 300,000 other people they represent, that kind of settlement has to be approved by the court. So they had to take it in front of the judge and get the judge to approve it. And that's what the judge did last month when the order came out and there was news saying the judge had approved the settlement. So one of the things the judge has to do in that circumstance is deal with anybody who is in the class but doesn't want to be, right? Because when a class is certified and there's a settlement, everybody in that class is notified. And it's like, okay, you have two options here. You can take your cut of the settlement, your cut of the money. But if you do that, then you're waiving your right to bring your own individual claim because you're saying this was my case. Or you can opt out of the settlement, which leaves you with the ability to bring your own individual case if you want to. And so people will opt out, or people will raise objections, or people will say, this is bad for me, this settlement is bad for me because I'm currently playing soccer at a D1 school and this is going to affect me. And so a lot of that happened just sort of like in a bankruptcy case, right? Like, what's everybody's objections to this? And then the court sorted through them, and the court dealt with them all, and then ended up saying, based on all of this, I approve this settlement. So there were a whole bunch of things in this settlement, and I think what's really important is to remember that part of this is getting the NCAA to change its rules. There were some rule changes that were mandated by this settlement, and this is where settlement can get you things that would be really hard to get in court. It would be a really uphill battle to have gotten this federal judge to demand and require that the NCAA change its rules, right? Courts mainly give people money, right? That's what civil courts do. It's about compensation. So the plaintiffs were able to get things in this settlement that they might not have been able to get in court. But first, the money. So the NCAA agreed to allocate $2.5 billion, which is probably nothing to them, for settlement of monetary claims for the people in that class, that 300,000 plus class. Subject to an allocation system that is so complicated it makes my head hurt. If anybody has a finance degree and wants to go through that, God bless you, I'm not doing it. But they said, here's the pot of money, and we will cut that up amongst the 300,000 plus people that are in this class. So that gives those people an immediate check, some immediate relief. In terms of the rule modifications, the big newsworthy ones were they raised the limits of what athletes can pay. Up to 22% of revenues can be paid to athletes. The NCAA can only ban NIL payments to students from one group, which is like boosters of the school, people who are already associated with the school. They can get NIL money from anybody else. And then one of the big ones was they are eliminating scholarship limits and replacing them with roster limits. That will allow colleges to give more scholarships to more athletes, because there were people who were scholarship eligible and the schools obviously had the money, but they had these limits in the NCAA of like, sorry, we can only give so many scholarships. And that was bullshit, because that was hurting not only the schools, but it was definitely hurting the students. So there are no scholarship limits anymore. There are now roster limits of you can only have so many people on your roster. So what's left dangling now is, as I said, the class only included certain sports, and it excluded other people. And so one of the things that was explicitly excluded from the settlement was Title IX violations, where female athletes were saying we were not paid equal with a percentage of what we earned for the college as the men were. So those were specifically pulled out of the settlement so that the female athletes could appeal the settlement based just on those issues, and they have done so. Which, that is their right to do. I think what's difficult is that the way the settlement agreement is written, the agreement is not final and does not go into effect until all appeals have been resolved. So my guess is that by filing that appeal, the Title IX female athletes are trying to just get at the allocation of the $2.5 billion to get a bigger chunk that they think they deserve. So I think this is good for sports, but let me know if you have any legal questions about it.